So today on the topic of what the High Court has to offer the public, we have Farouk Ahmed with us. Farouk is the Registrar of the PE High Court. Good afternoon to you, sir. How are you?
Good afternoon, David. Good afternoon to your listeners. I'm doing well, and yourself?
Very well, thanks. Coming from your background within the High Court, would you mind telling us about your role and maybe just a little bit about yourself?
I was initially in private practice as an attorney for 10 years. Then I joined the Master's Office, Master of the High Court here in Port Elizabeth for 6 years. And then around about December 2018, I joined the Office of the Chief Justice as the Registrar of the PE High Court.
So as the Registrar of the PE High Court, what does being a registrar actually mean, Farouk?
Okay. As Registrar of the High Court, I have various functions and duties to attend to. Amongst others, there is a supervision of staff, attending to default judgments, the taxation of bills of costs, and attending to queries from the public, as well as assisting in the smooth running of our courts. And then I must make mention of the Registrar and the Office of the Registrar, which would include the Registrar clerks. We are actually the heart of the court. And myself and my staff, we are the bridge between the practitioners, the public, and the judiciary. So some of the other functions that I need to mention is that we do issue civil processes, example summons, warrants of execution, subpoenas, notice of motions, and we lend assistance to the judges in general, and we keep records, compile case lists, and arrange courts, and make sure that all the necessary court staff are available when needed. So in terms of role players that we have at our court, we have obviously the judges, and they are assisted by the secretaries. And then in my general office for the civil section, we have civil clerks and case flow clerks. And then in our criminal section, we have our criminal clerks. So the High Court attends to both civil and criminal matters. So previously, the functions of a registrar were mainly administrative, but it has since changed. The registrar also has now what we call quasi-judicial duties or functions. And what I mean by that is the registrars now attend to default judgments and taxations of the attorney's bill of costs. So previously, those two items were dealt with by the judges, right? And the result of that is that it alleviates the workload of the judges. And the registrars now has powers to grant default judgments, in terms of which repossession of motor vehicles, for example. It's a speedy and inexpensive way of resolving matters based on liquid claims. So there's no need for the attorney to instruct an advocate to attend to court, and in that way incur unnecessary costs for the client. And then with regards to taxation of bills, so client obtains a court order in terms of which whichever relief he seeks, and there's a relief for costs. He wants to claim back his costs that he paid the attorney. And then the purpose of the taxation of the bill is to determine the reasonable charges and disbursements the successful party can fairly claim from the unsuccessful party. And then further to that, registrars also deal with fixing security for costs. And that would entail where plaintiff would sue a defendant in a matter, and the defendant is of the opinion that should the defendant be successful, the plaintiff won't have sufficient funds to cover his costs. So they would ask for the plaintiff to to provide security for costs. And that amount is to be determined by the registrar, taking into various factors. And then in terms of litigation, the registrar has a limited role to play, in terms of which previously the registrar used to allocate trial dates and the preparation of court rolls. This has been passed on to the registrar's clerks to assist with it because of the extra duties which the registrar needs to attend to. And then further we can add, I touched on that we attend to queries from the judges, practitioners and members of the public. Let's see. We offer support to the judiciary and ensure the smooth running of the court. And then just a quick one, how does one become a registrar? What are the requirements? The requirements presently is that you're required to have an LLB degree or a 4-year legal qualification. And if there's a vacancy, you make application as per the advertised post.
Now, as a general member of the public, I don't really know what services are offered by the court. Would you mind explaining those services to me?
Okay. So the High Court has jurisdiction over all matters, usually hears civil matters involving an amount of 400,000 or more, 400,000 rand or more, or less. So the parties to litigation, they can approach our lower courts where if they want to sue a party for 100,000 or less than 200,000, they can approach the magistrate's court, more specifically the district court. And if it's between, let's say between 200 and 400,000, we do have the regional court. And that's to save on costs because to approach the High Court is quite costly. We do have different tariffs which the attorneys are allowed to charge in terms of which for their fees. And the High Court tariffs is quite high compared to the Magistrates Court tariffs. Then the High Court also hears appeals and reviews, as well as we attend to interpretation of wills where there's a dispute, divorces, urgent applications. For example, if you want to stop a funeral, for example, then they could bring an urgent application to court, and urgent being after hours as well. We attend to, I mentioned previously, default judgments. So that is twofold in the sense that the registrar can only attend to default judgments based on a liquid claim. That's an amount that's ascertainable or a fixed amount. And where evidence need not be necessary to be led, the registrar can attend to that based on a liquid document. Where evidence is required, in other words, oral evidence, that will be heard in open court. And then we hear liquidation and insolvency matters as well as curatorship applications. That would be the High Court's role. And the constitutional matters would be referred to the Constitutional Court.
I've heard of directives issued by the judge president. Can you maybe explain to us what do they mean and why are they important?
Okay, so the judge president, more commonly known as the JP, for each division, would issue directives to ensure the smooth running of the courts and for uniformity purposes in our division. And these, you call them practice directives, they set out the High Court practice or procedure in the Eastern Cape Division. And as such, it seeks to inform how the courts in a specific division would function. It also seeks to obtain uniformity amongst judges in respect of practice rulings, as well as informing the attorneys or advocates the process followed in our division.
So why are the directives important, especially now during COVID-19 pandemic and national lockdown?
Okay. So from the onset of what we refer to as hard lockdown, March 2020, then the courts came to a virtual standstill in terms of which we could not have open court Open court, referring to where parties, litigants, and members of the public would come into court and sit in court and have the matter heard before a judge. So initially we started with, and there was a practice directive to that effect, whereby we would have virtual court for motion court matters. So motion court is heard on a Tuesday, so unopposed motion court, and the opposed motion court is heard on a Thursday. That we proceeded in terms of, we initially started with Zoom, and we've moved on to now Microsoft Teams. And then our civil trials that were sort of stayed or suspended because of the lockdown. And as the lockdown levels eased, we started slowly but surely opening our courts again. So the primary aim of those directives were to ensure ongoing access to justice by all parties to cases before the court, and to inform parties which platform would be used. When I say platform, I'm referring to its Zoom or Teams, and if it's going to be heard in open court.
I see. Thank you so much. Now, having said that, I know that there were many cases of, landlords trying to evict, renters who were not paying or not keeping their side of the bargain with regards to rental agreements. And in that process, this thing of fraudulent court orders came up. Now, what exactly is a fraudulent court order?
Okay. So a fraudulent court order could mean one of two things. Either the order that was granted was not in fact granted by a judge, and an official in the department signed off that order, right? And the other section is where the actual order given is changed by an official at the department or at the court, as opposed to what the judge actually ordered. So if it comes across that there's an alleged court order that is fraudulently issued, members of the public are always urged to verify its authenticity with the court from which it is allegedly issued. And then should any individual be unsure about the legitimacy of any court order, they should contact the Registrar's office of that particular court where the order is said to have been issued. And there are a number of things that an individual can look out for that can help ascertain the authenticity of a court order. So the things that you can look for is the order will have the emblem of the Office of the Chief Justice affixed to the top of it. Your older orders will have the coat of arms emblem affixed to it. Then it will state the division in which the order was made. For example, in the High Court of South Africa, Northwest Division, Mafeking, for example. It will also have the date when it was issued. It will state the name of the judge that issued the order, as per the following example: before the Honorable Mr. Justice Mamo Gale. It will state further the names of the plaintiff and the defendant. It will state the order given. The date stamp of the court will be affixed. It will be signed by a registrar and previously by registrar clerks. And the court seal will also be affixed to the order. Now, if it's determined that the court order in an individual's possession is not legitimate, the fraudulent court order must be reported to the registrar's office at the court where it was issued, and the matter must be reported to the nearest South African Police Service station for further investigation. And members of the public should be aware that it is a criminal offence for anyone to issue a document that purports to be a court order if it was not issued by a judge at the court. Yeah.
So Farouk, the average person on the street, when faced with the challenge of receiving a court order, whether they're being sued for whatever action they did, a lot of people don't really know what to do with that. So they either, wish it away, or, they might just take the wrong form of action from that point. What is the best thing for that person to do?
The best advice one could give is for them to attend the High Court, and more specifically the General Office, and they can consult with one of my clerks. And if he or she is unable to assist the client, they will refer the client to myself, in terms of which we would assist by guiding the client, in terms of which if they should apply for legal aid, for example, or we do have an option what we call informal pauperis, where we would actually refer the client, if they meet the requirements, that is, we refer them to an attorney. And the attorney, once they receive the instruction letter from my office, then they should consult with the client and see if, number one, there's no conflict of interest, if they have the necessary expertise to assist. If not, they need to, in writing, inform our offices. Then I would refer the client to another attorney. And if they are able to assist, then they will proceed to assist the client.
Thank you. And this service is offered for free, is that right, to the general
Yes.
public?
Yes. So everything at the High Court, there's no charges. We don't charge for our services. We are there to provide assistance and provide service delivery to the public.
On the other end now, from the other side, Farouk, if I, for example, I've had a situation where someone has stolen my car and I know who it is and I've opened up a case but nothing's being done, can I then approach the registrar to see how they can help me in taking the matter further to court?
Yes, what would happen in that regard, you report it to the police station, I presume. And if nothing has been done in that regard, then the best advice we can give to the client is you've got to report it to the station commander of that specific police station. And should there still be no assistance, then we'd refer the client to an attorney. And the attorney would then obviously write a letter of demand to the station commander, demanding that they look into the matter and take it further, failing which they would bring the necessary application to court.
Now, Farouk, another thing that happens quite often besides actual court orders is someone might be sent a lawyer's letter and they don't know what to make of that. You know, they don't know what to do. What's your advice to someone in that situation?
Okay. So I recall in practice, David, I should advise clients that, look, number one, it's a lawyer's letter. It's not a court order. So you get different types of people. The first would be they receive the lawyer's letter and they're just going to ignore it to his or her detriment. The next group is where they would refer the letter to their attorney to respond. And the third group would be the one that would be afraid of the lawyer's letter and adhere to the demands being made in the letter of demand. So my advice is, when you receive the lawyer's letter, is if you cannot afford an attorney, if you qualify for legal aid, take it to legal aid. If you belong to LegalWise, approach LegalWise. They will refer you to an attorney on their panel, or they're welcome to approach either myself, the Registrar of the High Court, or we do have a registrar at the Magistrates Court, the Regional Court, and maybe just try to get some guidance with regards to that letter of demand.
Also, Farouk, the average person doesn't have an attorney on call. Is it advisable for them to join or become members of LegalWise or Scorpion? What's your advice there?
Judging from my experience with LegalWise and Legal Scorpion, so if a member of the public applies to be a member of LegalWise or Scorpion, you get various categories in terms of which your premium they charge you, and your cover is based on the premium that you're paying. And if you do have a need for an attorney, then if you're a member of LegalWise or Scorpion, you approach their offices. They do cover certain types of matters. It's not all matters that they would cover. So they would have a panel of attorneys that will assist them. And based on your coverage, it's almost like an insurance. Based on your coverage, the attorney will be then, his or her fees will be paid through LegalWise or Scorpion based on the amount of your cover. Whether it's advisable not to be a part of them, I don't see why not, if they cannot afford a private attorney. And the cost, I believe, is not unreasonable. Be a member of LegalWise or Scorpion.
Well, Farouk, thank you so much for your time. Do you have any parting message to the public regarding understanding, what's happening at the High Court, or anything else that you'd like to touch on before we end off?
Okay. To the listeners, the staff at the PI Court, we are very accommodating, and we will try to assist as much as possible. We are there to provide service delivery, and I think if a client does have any issue with a specific individual at the court, they can take it up with his or her supervisor. If not, they can approach the registrar, which is myself, and we will look into it. But from what I've seen and what I've heard, we have always been obliging and open with clients, and we always try to assist wherever is possible.
Great. Well, thanks again, Farouk. I think the information that you've provided is so valuable, and I'm sure a lot of people can use it going forward. If anyone has any questions, outside of what we discussed, are they able to contact the registrar? Or are they able to contact the High Court if they have any other questions?
Yes, we do have a general office line. It's 041.
Yes.
502 6600. It will take them through to switchboard. And they are welcome to contact myself. My extension is 041 502 6640. And we are reachable on email as well. And my email address is as follows. It is Ahmed. So it's capital F, capital A, small letters HMED @judiciary.org.za.
Well, thanks again, Farouk. I really appreciate you making the time. Have a wonderful day further.
You too. Welcome.
Thanks.